Welcome to the Pro Bono Project YouTube video presentation on civil harassment restraining orders. My name is Lisa Cope Duflock, and I am a staff attorney with the Pro Bono Project Silicon Valley. In previous YouTube presentations, we have discussed domestic violence restraining orders, what they are, and how to get one. Today, we will turn our attention to civil harassment restraining orders. Civil Harassment Restraining Orders, or CHROs, are different than domestic violence restraining orders in that a civil harassment restraining order does not require any relationship between the parties. A domestic violence restraining order requires a marriage, immediate family, or dating relationship, whereas a civil harassment restraining order applies in all other cases. You can get a CHRO against roommates, neighbors, coworkers, former friends, in landlord-tenant situations, against aunts, uncles, nieces, nephews, cousins, etc. The California Code of Civil Procedures, Section 5277.6, sets forth the standard when someone can seek a civil harassment restraining order against another person. A person who has suffered harassment may seek an order prohibiting that harassment by the other party. You must be subjected to one of the following: unlawful violence, for example, assault, battery, or stalking; a credible threat of violence, a knowing and willful statement or course of conduct by another person that would place a reasonable person in fear of their safety or the safety of their family that serves no legitimate purpose; or a knowing and willful course of conduct directed at you as the petitioner that seriously alarms, annoys, or harasses, and that serves no legitimate purpose, and the conduct by its nature would cause a reasonable person to suffer substantial emotional distress and did in fact cause you as the petitioner substantial emotional distress. The civil harassment restraining order must be for a harassing course of conduct, which can be a series of acts over a period of time, even a very short time, which evidences a continuity of purpose. The harassment is unlawful violence, a credible threat of violence, or a knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, or harasses that person, and again, serves no legitimate purpose. Examples of this kind of harassment include extreme verbal abuse, stalking, harassing, actual acts of violence committed against you, threats of acts of violence. The course of conduct must be that which would cause a reasonable person to suffer substantial emotional distress and did in fact actually cause you substantial emotional distress as the person requesting the CHRO. A course of conduct is a pattern of conduct composed of a series of acts over a period of time, even a short period of time, evidencing a continuity of purpose. A single incident of harassment is not enough to get a civil harassment restraining order, but a single incidence of violence is sufficient. When petitioning the court for an order against the party who is harassing you, you can request both personal conduct orders and stay-away orders. Personal conduct orders means the other party must stop calling you, stalking, threatening, emailing you, any kind of conduct or contact with you. Stay-away orders means that the other party must stay a specific distance away from you, your home, your school, your workplace, etc. This can be up to 300 yards or 3 football fields. What can a civil harassment restraining order not do? In a civil harassment restraining order, a judge cannot order the other party to move out. It cannot work as an eviction or any other method of getting someone to vacate premises. A judge will not make or enforce child custody, child visitation, or child support orders. A judge will not order the other party to pay money that they owe you. A judge will not order the other party to pay you any damages for property damage or injuries you suffered. However, you can bring a civil action to force the other party to pay money back to you or to recover those damages for property or injuries. A judge will not issue a civil harassment restraining order to improperly take away the other party's constitutional rights, including the rights of free speech, privacy, due process, and property rights. There are also privileges that the court will not take away by issuing a civil harassment restraining order, such as the privilege to complain to governmental organizations, such as calling law enforcement authorities to report a suspected crime if that phone call is made in good faith, and including complaints to other agencies, such as IRS, Immigration and Naturalization Services, and Child Protective Services. So, what do you have to prove to get a civil harassment restraining order? In a nutshell, to get a civil harassment restraining order, you must prove why you are in fear based on the actions by the other party. The judge will make an initial decision based on reading your papers and deciding if a temporary restraining order will issue or be denied until the final hearing. Whether the temporary restraining order is issued or not, the other party will have the opportunity to respond prior to the final restraining order hearing. At the hearing, the judge will make a final decision for a permanent CHRO for up to 5 years, based on the testimony of both parties, evidence, witnesses, and the written petitions. How convinced does the judge need to have to be to grant your civil harassment restraining order? This is the burden of proof. You may have heard on television that proof beyond a reasonable doubt is how convinced a jury must be before convicting someone of a crime. But when getting a civil harassment restraining order, you need to provide clear and convincing evidence for the judge. This is a lower standard than beyond a reasonable doubt. You must present to the judge clear and convincing evidence of unlawful violence, or that a credible threat of violence has been made, such as the other party threatened your life or family or done physical harm to you, falls into the category of a credible threat of violence. Or there is an ongoing course of conduct. Again, a course of conduct is a period of time, however short, that shows a continuity of purpose to the harassment. A one-time nonviolent incident is insufficient because it is not a course of conduct. And this course of conduct must be directed at a person, not a group, an organization, or a location. Furthermore, this course of conduct must be one that seriously annoys, harasses, or alarms you and serves no legitimate purpose. For example, telling the landlord that there is a problem with the premises would serve a legitimate purpose, such as habitability, etc. Furthermore, the conduct must be knowing and willful, not inadvertent. It must be directed at a specific person, you as the petitioner, not behavior directed at the world in general. Moreover, the conduct must be such that it would cause a reasonable person to suffer a substantial emotional distress. And, in fact, it actually causes you, as the petitioner, substantial emotional distress. You may be very distressed, but a reasonable person would not be substantially emotional distressed. Thus, the court requires that an average person must be substantially emotional distressed by the conduct and must have actually suffered emotional distress. You can demonstrate that you actually suffered substantial emotional distress through evidence of lost sleep, lost work, anxiety, doctor's bills, appointments, whatever it is that you can use to show you did in fact suffer substantial emotional distress. The standard of clear and convincing evidence is a pretty high standard. It requires proof that it is highly probable that the facts the petitioner is alleging are true. It may require more than just both parties testifying to the court under oath. It may need corroborating evidence or witnesses. An ongoing practice of verbal abuse, name calling, stalking, etc., that alarms, annoys, or harasses, a consistent pattern of behavior is a good way to prove to a clear and convincing standard. A need for protection from physical harm or serious emotional distress is what the judge is looking for. There is a fee to file for a civil harassment restraining order, but you can ask the court for a fee waiver so that you do not have to pay those fees. An exception to the fee requirement is there is no filing fee for a petition that alleges the other party has inflicted or threatened violence against you as the petitioner, stalked you, or acted or spoken in a manner that has placed the petitioner in reasonable fear of violence. If you do not meet the requirements for a fee waiver, you can petition the court for a fee waiver. And please see our fee waiver videos that accompany this video. Basic outline of how to get a civil harassment restraining order. First, you need to complete the forms. See our companion video on civil harassment restraining order forms. File the forms with the court. Bring 3 copies. In Santa Clara County, your forms are filed at the downtown courthouse located at 191 North 1st Street, San Jose. Bring the forms to the court specialist calendar office on the ground floor of the courthouse. The court specialist will give you a slip of paper to let you know when your forms will be ready. You must then return to pick them up. They will not be mailed to you. If you are also asking for a temporary restraining order, the court will decide within 24 hours whether or not to make the order. In Santa Clara County, if the papers are filed by 1:30 p.m., a ruling will be made on the same day for the temporary restraining order. A temporary order only lasts until the next hearing date. When you pick up the forms, you can look at them to see if the judge granted the temporary restraining order. And there will also be a hearing date for your final hearing on the forms. After you have received the temporary order, you must have a copy of the forms served on the respondent. Someone over the age of 18, not you, must serve a copy of the forms on the other party in person at least 5 days before the hearing, unless the court has shortened time for service. The person serving the forms for you must then fill out and file Form CH-200, proof of personal service. Or you can request the sheriff to serve the forms on your behalf. Prior to the hearing, you want to review the written opposition from the other party if any was filed. Then attend your court hearing. If you do not attend the court hearing, the case will be dropped and the temporary restraining order will expire. At the hearing, you want to bring evidence and witnesses to your hearing. Make 3 copies of all evidence and forms to bring. This includes photographs, medical reports, police reports, threatening letters, emails, text, social media posts, telephone messages. You can also bring witnesses to the hearing. If your witness is not able to attend, you can bring a written statement from the witness that is signed by them and made under oath, and that can be presented as evidence at your hearing. As the petitioner, if there are allegations of violence or threats of violence, you can bring a support person with you to provide you support during the proceedings. This person cannot speak on your behalf or provide legal advice, but they can sit with you to provide emotional and moral support. If the restraining order is granted at the hearing and the other party is not there, you must have the restraining order after hearing served on the other party, as discussed above, for personal service. Service is completed by someone over the age of 18, not you, who then fills out and files Form CH-200, proof of personal service, or it can be served by the sheriff. How long does a civil harassment restraining order last? The temporary order only lasts until the final court hearing. The final civil harassment restraining order issued after the court hearing can last up to 5 years. As the petitioner, you can ask the court to renew the civil harassment restraining order if there's an ongoing threat of harassment or violence. A CHRO is only ended by expiring or by a court order. How do you enforce your civil harassment restraining order? Once the court issues the civil harassment restraining order, keep copies of it in multiple places: your car, your work, your purse or backpack. your child's school or daycare. If issued, the civil harassment restraining order will require the other party to get rid of all guns or ammunition for the duration of the civil harassment restraining order. The civil harassment restraining order can last up to 5 years and can be renewed by the requesting party. If the restrained party violates the order, call the police. They can be arrested for violating the civil harassment restraining order. The restrained party can also be subject to the contempt power of the court and receive financial sanctions for violating the civil harassment restraining order. Thank you for listening to our Pro Bono Project YouTube video presentation on civil harassment restraining orders.